Good morning.
There is nothing, it's just to advertise the post that's in Ghana, I mean, he did 3 years without give up. Very ambitious.
For pronouncement of judgment, item number 21.
View of the discussion made above, petitioner has not been able to make out a case. Petition stands dismissed.
All right.
May I please, Lordship? My lord, I beg to mention item number 4 on behalf of K. Angami, my lord. Kindly list the matter after vacation, my lord. I am informed that he has taken consent from the opposite party.
Yeah, item number 4.
Item-
Yes, ma'am.
Item four.
Your lordship, this is very long pending matter and matter is very small, your lordship. This is a matter for quashing of FIR.
Hmm.
Then that cause of action arose in Jharkhand. And it is categorical in the FIR that PO.
No, but the advocate who's appearing the matter is. not present.
Actually, state government is here, but other private respondent, who
private
is the
respondent.
main, they are not appearing, your lordship. They are not appearing.
Notice complete.
Notice complete. Once they appear probably, and after that, they are not appearing. And matter is also not very big, your lordship.
Item number 4. The lordship.
Oh,
In item number 4, I'm appearing for the private respondent, lordship.
Okay.
I was informed today morning that the state wants to take some time.
But you are the main party. You
I
are,
understand, lordship, but somehow we were asked to. Lordship.
yes. So are
But
you, can we take it up today?
if your lordship is, I'm ready with it. Or if your lordship wants to fix date, get the date, lordship.
State,
My lord,
Yeah.
Audible, lordship.
you have something to say. in this
Yes, my
case.
lord, I'm mentioning on behalf of K. Angami and I will not be available, my lord.
The state respondents were directed to produce the case diary
No idea,
Were
my
you-
lord. I'm not handling the case, my lord.
because records, they may be having the records also. No?
yes.
Then
After vacation, my lord.
After vacation, then only, your lordship.
Number 4.
And then, and fix date. To the
Yes, yes.
convenient of my learned friend in
Yes,
Jharkhand.
you give a date after the summer vacation. You give a date after 13 July.
Lordship.
After 13 July,
Lordship, any date convenient with this, lordship.
16th. List on 16 July.
Lordship.
2025.
My lord, 16
On-
is Wednesday, my lord.
Or TV.
17th. 17th on the prayer of the parties. Yes, we'll just say that.
Much obliged.
Much obliged.
May I please, your lordship?
Deeply obliged, lordship.
I beg to mention item number 19. My seniors, 19.
19.
My seniors currently disposed of this matter release after vacation.
19, and the prayer of the learned counsel for the petitioner is the matter after the summer vacation. Prayer is not objected by the respondents. Yes.
Maybe Sir Lordship, Lordship, I beg to mention hearing item number 18 on behalf of N. Angami Lordship, if this matter can come out after vacation, Lordship. 18.
Mention is made by Ms. such and such on behalf of
N. Angami.
Mr. N. Angami, Learned Government Advocate, to list the matter after the summer vacation for hearing. Learned counsel for the petitioner is present and has no objections. List after summer vacation.
Obliged, Lordship.
Please, my ladyship, I beg to mention item number 9.
9.
Yes,
Yes.
I have instruction to appear on behalf of the sole respondent. I found my Vakalat number this morning.
Hmm.
So I pray that 3 weeks time may be granted to obtain the instructions.
Learned counsel V. Shukre has submitted that she has received instructions to appear on behalf of the sole respondent and would like, how much time?
I found my Vakalat number
Okay,
this
and
morning
that she
to
will-
obtain instruction.
And that she has filed the Vakalat number today. She prays for 2 weeks,
3 weeks.
3 weeks time to receive instructions. Prayers allowed. List the matter after 3 weeks. Learned counsel for the petitioner, Mr. Eli Rao, is present.
Much.
Yes.
May I please, Your Lordship? Right, Your Lordship, I wish to mention item number 7. This morning I have received the affidavit in reply from the party. Therefore, the matter may be listed after vacation.
No, I'm appearing for item number 7, 8.
Mm.
We have served the copy today itself.
Mm.
So if it is not inconvenient to your lordship, can it be on 28th of July?
28.
14th, it will after vacation. It's a Monday.
It will reopen on 14th, of course.
Yes,
Will
of course,
reopen on
yes,
28.
28th. If it is, my learned friend is on the other side, he's on VC. If it is not inconvenient also for him.
28.
28, if it is convenient. for my-
28th
It's
of
a
July,
Monday.
July, my lord?
28th of
July, it's a Monday. After vacation, it will,
Very well, my lord. Very well. 28th.
I think, 28, it's okay for you?
28th is fine.
Yes, 28.
Okay. Mr. Ketovi, learned, your appearing is
Yes,
PP, no? Learned PP for the respondents has submitted that he has received a copy of the affidavit in reply this morning and accordingly prays for listing the matter after the summer vacations. So, Senior Counsel, Mr. D. does for the petitioner is present. And he has prayed for listing the matter on 28th of July. Which is agreed to by the learned counsel for, you are for,
I'm the Special Counsel for Enforcement Directorate, Zohaib Hussain.
Mr. Such and such special counsel for the ED. Also has no objections. Okay, list on 28
July.
July.
There is an interim
Yes.
order, item number 7. ma'am.
Okay, item number 7, the interim order passed earlier shall continue till the next day.
I am deeply obliged, ma'am.
Pleasure.
Deeply obliged.
Obliged.
No, please, your
Yes,
lordship, I
yes.
beg to mention item number 12. I'm appearing on behalf of my senior, Nito
Hmm.
Koza, counsel for the petitioner.
Hmm.
The affidavit in reply is still under preparation, so kindly grant us 2 weeks' time to file the same.
Reply to the affidavit in opposition.
Yes, your lordship.
Okay. Counsel for the petitioner, Ms. Such and such has prayed for
2 weeks.
2 weeks' time to file a reply to the affidavit in opposition filed by the respondents. Stop prayer is allowed. List the matter after 2 weeks. Learned Counsel, Mr. Mohan Jamir is present for
2 and 3.
2 and respondents 2 and 3. So list after 2 weeks. Yes.
May I please, my lady? My lady,
Yes.
I'm appearing through VC, my lady.
Yes.
My lady, I beg to mention hearing item number 16, my lady. I'm very sorry I could not appear before this honorable court today, though it is a fixed matter.
Mm.
I have already informed my senior colleague. My lady, actually, on last Saturday, my whole system got crashed down. And as a result of which, I could not print out the argument as well as the citations which I've prepared to present before this honorable court. In that eventuality, my lady, if it can be fixed on Thursday, my lady.
May it please, your
I'm
lord.
just-
If this matter can be fixed after vacation, that is on 21st of
After
July,
vacation, then
21st of July.
Yes.
March.
Learned Counsel for
Deeply
the
obliged, deeply obliged.
praise for listing the matter after a week as he has some difficulties today. Stop. Learned Counsel for the appellant, Mr. Inti Wapang, has prayed for listing the matter for hearing after the summer vacations. Stop. Accordingly, lists after summer vacations. For hearing. Yes.
Obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention hearing item number 17. I've taken the consent of the respondent. Can it be listed after the break,
After summer break,
after summer break, Lordship?
this the matter for hearing after the summer vacation on the prayer of the learned counsel for the petitioner with the consent of the respondents.
Obliged, Lordship.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 11, Your Lordship, on behalf of Imna Sinla.
Huh.
Lordship, she is indisposed today, Your Lordship. So this meeting come up on 21st of July.
Mr. I. Jamir mentioning on behalf
Medovero.
of Medoveris, mentioning on behalf of
Imna Sinla,
Im Nasinda, praise for listing the matter after,
on 21 of July. Consensus prayer, Your Lordship.
okay, on the 21st of July. 2024, prayers allowed. The learned counsel for the respondent is present. List after, list on 21st July.
Much obliged, Lord.
Lordship, item number 14, similar prayer, Lordship. May this matter be listed on 21st.
Item 14 also, 21st July, on the prayer of the parties.
Obliged,
Much
Lord.
obliged, Lord.
For motion, item number 1.
May it please your lordship. This is a quashing petition filed jointly by the accused as well as the complainants with regard to quashing of the criminal proceedings currently pending before the learned JMFC Kohima, GR 157, based on the compromise which the accused as well as the complainants have entered into. The FIR is at page 15. Should I read out?
No, it's okay. Date,
Dated 11 November.
and the compromise,
The compromise at page 24. This has been signed by the accused, the two complainants, as well as the apex tribal bodies of both the accused and the complainant.
is who's appearing for the state? You get this.
Yes, my lord. Let the record be called from one.
This application under section 528 of the BNSS has been filed, praying for proceedings in GR 157/2024 pending before the learned JMFC Kohima, and also the connected FIR arising out of cybercrime PS case number 011/24 under section 352/353 clause 2 BNS on the basis of a compromise deed executed between the accused and the complainants on 30th May 2025. Stop. The petition is filed jointly by the complainant and the accused. Stop. Learned PP Thiba Pom accepts notice on behalf of the state respondent. Hence, no formal notice is called for. Stop. List the matter after
Vacation, my lord.
after the summer vacation. On the next date, the learned PP shall obtain a scanned copy of the case diary.
Lordship, I have an interim prayer. Now, given the nature of offences, which is neither serious or heinous, may I pray that the trial be suspended.
Till the next date, the proceedings in GR 157/2024 shall remain state. Before the learned JMFC shall remain state.
I'm deeply obliged.
Much obliged.
Item number 2.
May please, your lordship. Your lordship, this is file under 173 Motor Vehicle Act against order passed by the.
But there's a delay, isn't it?
Yes, yes, your lordship.
IA in the IA. This application under section 5 of the Limitation Act has been prayed for condemnation of delay of 19 days in filing the connected MSC appeal. Stop. I've heard learned counsel for the appellant, Mr. Kedovi. Issue notice on the IA. Returnable within 4 weeks. The petitioner shall take steps for service on the respondents number 1 to 7.
1 to 7.
Respondents number 1 to 7. What about performer?
Performer respondent. Your lordship.
Number 1 to 7, as well as the performer respondent by registered post with AD. as well as usual process within a period of 3 working days from today. Is the matter after 4 weeks.
For admission, item number 3.
Wait, please, my lordship. Lordship, on 3/4/2025, personal appearance was ordered. However, they did not appear. So on 19/5/2025, the last order, lordship may kindly peruse the last paragraph.
19/5.
Yes, that was the last order.
Such and such is submitted by. Yes, issued.
Lordship, I am for the respondent number 2. I've communicated to the department, but the problem is now the matter is under examination, and as we have submitted earlier also for one of certain documents, we could not complete the job.
Then why do you give false assurance that it will be issued within 4 weeks?
No, it was my submission is very limited on the other side, as per the last order.
No, here it says, however, it is submitted by counsel for the respondents that they assure that the appointment order will be
Yes.
within 4 weeks.
Submission now.
Yes, I'm for respondent number 2, and then this for respondent number 3. Regarding the some documents we
You are for 2.
we have.
And Mr. Imti is for 3.
3, yes.
As per the instructions of the respondent number 3, we have sought some documents from the Office of the Accountant General regarding the service records. But we were informed that the records are not available in the Accountant General's office.
Then where will it be?
So we are trying to trace the records from the pension cell.
No, but for compassionate appointment, what records you need?
Yes, we were asked to produce the service records of the petitioner's father. Because we have already sent for the proposal to the government for appointment. But they have
For
again, yes.
appointment of the petitioner.
Yes, we have already sent the proposal way back on to March. On 4th of June 2024.
And what, service book for what?
The service book of the petitioner's father.
Why?
We were asked from the government, not from the department, because we have already sent the proposal for appointment of the petitioner on 4th of June 2024.
Because for compassionate appointment, you only need to know that the petitioner's father or mother was in service and that they died in harness. That's all.
So we have sent the proposal on 4th of June 2024 for appointment. Now, without the approval of the government, we cannot issue the appointment order without the government approval. So we have sought the approval.
Sure.
On 4th of June 2024.
This is not. Respondent 2 and 3 will have to appear because it's very clear in the last order. In default, R2 and 3 will personally appear. Let them appear and explain to the court.
In that case,
We'll list it after the summer vacation. And then on that day, if they can't issue, then they have to come personally. Learned counsel for the petitioner, Ms. Letzi Mumi is present. Also heard Mr. N. Nongkumar counsel for the respondent number 2, and Mr. Im Tim Song, counsel for respondent number 3. Stop. By the order dated 19/5/2025, this court had directed that the respondents are to comply with the order of this court dated 14/2/2020 on or before the next date of listing. Stop. In default, the respondents number 2 and 3 will personally appear before the court and will show cause as to why, in spite of repeated directions, the order could not be complied with. Stop. Next paragraph. When the matter is called today, the learned counsels for the respondents have again prayed for time on the ground that certain documents are still required. No, certain documents had been sought from the Office of the Accountant General, which is yet to reach the concerned department. And accordingly, the appointment order could not be issued. Stop. List the matter on is 24th July, matter on 24th July, on which date the respondent number 2 and 3 are directed to appear personally before the court to show cause as to why the directions of this court could not be complied with. So,
Item number 5.
May I please, Your Ladyship?
Yes.
I'm representing on behalf of my senior Takakichu. As my senior is out of station, so if this matter may be listed after summer break.
You are for the appellant?
Yes.
Maybe listed on 21st July.
Okay. Learned counsel for the petitioner, Miss such and such.
Piyang ako niya. Okay.
Write and give it to. She has made a prayer on behalf of the leading counsel, Mr. Takakichu, to list the matter after the summer break, as he has some difficulties today. Stop. Learned counsel for the respondents, Mr. P. N. Sharma and Mr. M. T. Wapang are present. So, list the matter on 21st July, 2025.
Item number 6.
May it please, Your Lordship.
Yes.
Lordship, I am appearing for the appellant here. IA 97 of the 24 is for delay, condonation of delay of 47 days that occurred in filing the MSc appeal, my lord.
IA 97.
My lord.
You are for the appellant?
My lord.
Okay. Objection filed. Are you objecting?
I shall submit already. Yes, Lord.
Yes, let's hear on the condonation. What is your paragraph? Let's see. Your relevant paragraph.
This paragraph number 5, my lord. Page number 5.
Yes, please read.
It is stated that the engaged counsel of the company informed about the judgment and award dated 16/2/2024 to the company, and accordingly certified copy of order was sent to the regional office of the appellant company on 26/2/2024. And receiving the same, the engaged counsel was requested to send all the papers of the case for future course of action. Accordingly, all the relevant papers of the case were collected from the engaged counsel on 15/3/2024, and it was forwarded to the head office at Mumbai for information and necessary action on 23. In turn, On 28/3/2024, the head office at Mumbai directed the regional office to obtain an opinion of an independent advocate to the effect whether there is a scope of appeal or not. As directed by the head office on 8/4/2024, the relevant papers were forwarded to an appellant advocate with a request to form an opinion whether there is any scope to prefer an appeal. It is stated that on 26/4/2024, the appellant advocate gave his opinion that there is a good ground to prefer an appeal against the judgment and order dated 16/2/2024 as there was Bihu holidays in between, and after obtaining from the panel advocate, the same was possible to forward to the head office only on 10/5/2024. Thereafter, the matter was processed in the head office, and on 25/5, the matter was remanded to the regional office with a direction to prefer an appeal against the judgment and order dated. There is a typographical error. It should have been 16/2/2024. It is stated that as per the direction of the head office, the papers were ultimately sent to the advocate on 7/6/2024 to prepare and file the appeal. It is stated that all this process took substantial time, and in doing so, the limitation period of 90 days expired. It is stated that the engaged counsel finalized the draft of the memo of appeal in last week of June and sent the draft to the memo of appeal to the regional office for waiting as per company's procedure. It is stated that the office was overburdened. The relevant file was returned only on 29/6. It is stated that the final settlement of the memo of the appeal could be filed only on 2nd of July, my lord, it should have been. And by the time 47 days of delay has occurred, my lord. My lord, basically it's a process, my lord. Since the office is at Mumbai, my lord, the communication took a little time. In Gauhati, it is regional offices in Gauhati. And all the finalization of appeal and all things are done at Mumbai head office, my lord. And therefore, finally, the appeal was filed on 2nd of July. By that time, my lord, 90 days have already passed by and 47 days more has occurred.
Okay. Anything? 47 days, you're objecting, seriously?
Lordship, actually, there is a 137 days delay.
137
days.
137
Yes,
days.
Lordship. I have prepared a small gist. May I forward a copy, Lordship? Wherein 90 days delay remain unexplained, Lordship.
Judgment and award is 16/2.
16/2/24, date of judgment, and appeal file on 2nd July. So there has been a total delay of 137 days. So only 47 days delay is explained. So 90
6
days.
June, filed on 2nd June.
2nd July.
July, my lord.
2nd July.
July, Lordship.
2nd July 22.
So 90 days delay is remain unexplained, Lordship.
If I may submit, my lord.
Yes.
My lord, the paragraph form, I have explained it from the day of the order, my lord. The first, the council applied for the certified copy. Since then, I have explained the whole thing, my lord. From the judgment and order dated 16/2, if the lordship kindly peruse the paragraph number 5, my lord, that it is stated that the engaged counsel of the company informed about the judgment and awarded it 16/2 to the company, and accordingly,
It is already submitted before your Lordship. There should not be any repeat.
No, paragraph 5, you have already read
Yes,
out.
Lordship. My counter is, my objection in regards to the para 5 is, Lordship. In para 5.
Oh, you have
In the-
filed an objection?
Yes, Lordship.
I have not received a copy, my lord.
Lordship,
Objection copies.
no, I have not filed objection.
Okay.
Yeah,
You
I
are
am-
verbally submitting.
Yes, I am verbally submitting, Lordship. I am not filed objection. In para 5, against their reason of delay, the delay condonation petition alleges about the reason of delay which are appeared to be suppression of material facts and delay caused due to their negligence and lethargy. However, from the statement made in para 5, appeared hereunder. 1. There is no explanation when the engaged counsel of the appellant informed about the judgment and award. In para 5, vaguely they were stating that the delay was because of the maintenance of the official procedures and movement of file from one table to another, Lordship. That cannot be a good ground, Lordship. Here in Lordship, again, alleged or engaged counsel requested the all case records, when and why, no explanation. Though head office asked the regional office to obtain further legal opinion 28/3/24, however, the regional office, because of their lethargy, could able to forward the file for legal opinion after 12 days on 8/4/24. Also, no explanation when the file handed over to the council, only alleged opinion received on 26/4/24, Lordship. Allegation is that, Lordship, there was a Bihu festival. Interesting. Between and after obtaining opinion from the council, it is surprising enough that the Bihu festival was over by 14 to 16 April. Even before receiving of opinion that at 26/4/24, which is appeared to be perverse explanation, despite the fact or regional office could able to forward the file allegedly on 5/24 after 15 days due to their inaction, though the appellant know about the time of filing of the appeal, Lordship. Alleged, even after receiving papers on 25/5/24, forwarded the file to the council on 7/6/24, that is after inordinate delay of 14 days. Lordship, no explanation about when the council sent the record to the regional office for signature. It is not there, Lordship. Allegation is that office of the appellant was overhead burden, due to which able to return the file only on 29/6/24. If so, how the appeal stated to be filed on 15/5/24 as stated in para 5, and the relevant portion of the in para 5, para 6 is as here. It is surprising enough that in connected affidavit in para 6 categorically stated that the documents annexed to this bail application are true copies. It is very interesting, very casual.
Learned Counsel, I think you have filed this petition very casually. Even the date of the order is wrong.
Yes,
the date of filing is wrong.
No, my lord, the date of filing is wrong, but it is in the starting of the
Very
paragraph. If
interesting,
my
Lord.
learned friend allows me
No,
to
this
speak,
is
my
my
lord.
submission. Please stop.
In
This is
your
my submission. While you are submitting, I am not raising any objection. So this is my time. Yes,
Go,
Lordship.
continue.
Yes. In the affidavit, Lordship, supported the petition of the condonation of delay. What is stated, Lordship? It is surprising enough that in connected affidavit in para 3, categorically stated that the documents annexed to this bail application are true copies of the original and of the copies as made available to or obtained by the petitioner, and as such are believed to be true copies of the originals. This is the practice, what is prevailing here, Lordship. How much casual? The explanation of delay caused by the appellants due to their movement of file from one table to another, also the negligence of the appellant in all respect, as such is liable to be dismissed, Lordship. The respondent claimant for satisfaction of this court is relied upon the following decision of our apex court, Lordship. Alleged delay caused for movement of file from one table to another for seeking permission to file appeal. Entire delay is because of lethargy and inaction of the appellant. The petition filed by the appellant is devoid of material fact and particulars at very belated stage without proper explanation, file appeal. At the circumstances, submission of the appellant, delay was not their negligence and willful is totally perverse and no delay can be condoned, Lordship. While condoning the petition for condonation of delay, merit of the appeal cannot be looked into, whereas reasonable and factual satisfactory explanation is required, Lordship. To condone delay must be explained the whole period, however, not a part. In Sitaram Ramachandra, etc., this is a full bench decision, Lordship. In para 19, Lordship. Full bench decision in para 19. Air 1960, Supreme Court 260, relevant para 19, Lordship. It cannot be disputed that in dealing, Lordship, in my written submission, page number 4, first paragraph.
No, where is the written submission?
No, in my gist of argument.
Oh, here?
Yes, I have mentioned there. In page number 4, first paragraph, Lordship.
Nagarshana.
Yes, Lord.
Sitaram
In Sitaram Ramasarana, etc. versus M.N. Nagrasana and others, AIR 1960, Supreme Court 260, full bench, relevant para 19, Lordship, held it cannot be disputed that in dealing with the question of condonation delay under Section 5 of the Limitation Act, the party has to satisfy the court that he had sufficient cause for not preferring the appeal or making the application within prescribed period, and this has always been understood to mean that the explanation has to be covered the whole period of delay. There has been a 137 days delay, so entire period must be explained, Lordship, as per this judgment, Lordship. The Honorable Supreme Court in Ketna cases held that when a litigant applies to condone the delay in filing of an appeal, then they should also explain why the appeal was not filed within the limitation period itself. In other words, an explanation of the delay from the period when the limitation ends is not sufficient. Here in Lordship, after limitation period, only explanations are forwarded before the Lordship. That is not possible. Entire period to be explained, Lordship. They have to explain why appeal was not filed before expiry of the limitation period, Lordship. This Honorable Court in interlocutory application number Civil 147 of 2024 in New India Insurance versus Lakhimai Devi, Maya Hazarika, Lordship. In para 7, held that having considered the submission of the counsel for the parties and
have given me the wrong order.
Maya Hazarika. In para 7, Lordship, held that, may I read, Lordship?
Yes.
Yeah. Having considered the submission of the counsel for the parties and upon going through the application under Section 5 of the Limitation Act, this court is of the view that the entire explanation given by the applicant is based on administrative formalities and movement of files from one table, which are not valid ground in view of the advancement of modern technology, which allows speedy communication even from far-flung areas. This court has also observed that there is no explanation at all with regards to 249 days in between the judgment dated 17/5/23 and the letter dated 21/1/24, which the panel advocate had written to the claim department office, forwarding the legal opinion. And in para 8, please to dismiss the appeal, Lordship. Their application was dismissed.
But in that case, the delay was huge. It was 400 something days.
Yes, 249 days delay. And there was no proper explanation for the entire period of delay. And
It was 490 days
yes, Lordship.
in that other case.
Yes, Lordship. Here, Lordship, in my gist of submission, here it is Ikra Ahmed versus Sip Devi, reported in 2018 SEC online, Allahabad 5950, wherein Honorable High Court of Allahabad referred to the judgment of Honorable Apex Court in Mani Debraj Shah versus Municipal Corporation of Barhin, reported in 2012 5 SEC 157, wherein it was observed as follows, Lordship. In para 23, Lordship, what need to be emphasized is that even though a liberal and justice-oriented approach is required to be adopted in the exercise of power under Section 5 of the Limitation Act and other similar statutes, the court can neither become oblivious of the fact that the successful litigant has acquired certain rights on the basis of the judgment under challenge, and a lot of time is consumed at various stages of litigation apart from the cost. In para 24, Lordship, what color of explanation sufficient cause would get in the factual martics of a given case would largely depend on bona fide nature of the explanation. In the court, find that there has been no negligence on the part of the applicant and the cause shown for the delay does not take bona fides. Then it may condone the delay. If, on the other hand, the explanation given by the applicant is found to be concocted or he is thoroughly negligent in prosecuting his case, then it would be a legitimate exercise of discretion not to condone the delay, Lordship. Lordship, in State of Assam and others versus Gitarani Kolita and others, 2017 to GLT 1190, it is a divisional bench judgment, Lordship. In para 7, 8, 9, and 10, the Honorable Division Bench, by referring the judgment of the Honorable Apex Court in the Office of the Postmaster General and Living Media India Limited, reported in year 2012, Supreme Court 1506, wherein it was held that claim on account of impersonal machinery and inherent bureaucratic methodology of making several notes cannot be accepted in view of modern technologies being used as and available, and that the law of limitation undoubtedly binds everybody, including the government, Lordship. Very recently, our Honorable High Court in interlocutory application civil 3 of 21 dated 11/5/23, National Insurance Company Limited versus Nondokanai Pegu. Yes. Held in para 13, time consumed in following the administrative procedure and for correspondence between various regional divisional office of the appellant company, the appeal could not be preferred within the prescribed period of limitation does not appear to be a sufficient cause to condone the delay. Further, submission of the learned counsel for the appellant that delay cause was in view of circumstances which were beyond the control of the applicant is also not acceptable, as the internal procedure of the applicant company for taking a decision for preferring an appeal under Section 173 of the Motor Vehicle Act 1988 has been devised by the applicant company itself, knowing fully well the period of limitation prescribed by the statutes. When the applicant company has itself devised its own internal procedures, it cannot be said that same was beyond the control of the applicant, Lordship. And the thing is done by them, how they can say that the delay caused because of beyond the control, Lordship. In ICICI Lombard General Insurance Company Limited versus Somnath Brahma, Chaudhuri, and others, 2017 to GLP, page 487 in para 6, Lordship. The ground of delay of 99 days as alleged in the petition due to movement of file from one table to another. Statement reflected that the applicant was casual in all stages of decision-making process in the branch level, regional level, and in the head office level. Said cause are held not to constitute just or proper or good or sufficient cause for which the connected appeal could not be filed on time. Further held, the insurer, like the applicant, who are in a business of insuring the citizens and goods in the country, have a social responsibility to see that at least they do not become a source of prolongation of litigation under the social and beneficial legislation. Accordingly, prayer of 99 days delay in presenting the connected appeal is rejected, Lordship. Lordship, Commissioner of Voltex, Bombay versus Amateur Writers Club, Bombay, 1994, supplementary to SCC 603 in para 3 and 4, Lordship, held explanation of delay mentioning the date of movement of documents between the office concerned and the council. Such stereotype affidavit held indicative of indifference and condonation of 264 days delay refused, Lordship. The petitioner appellant in para 5 in page number 6, it is respectfully stated that as the office was overloaded, for the reason appeal could not file in time, Lordship. That is also another ground that their office was overloaded. As such, they are unable to file the appeal, Lordship. What is the ground, Lordship? Here, Lordship, in P.K. Ramachandra versus State of Kerala and others, AIR 1998, Supreme Court 2276. At the relevant time, Advocate General Office was hit up with so many arbitration matter pending consideration, can hardly be said to be a reasonable, satisfactory, or even proper explanation for delay, Lordship. In the affidavit, filed along with the petition for condonation of delay, it appeared prepared very casually, wherein in paragraph 3 stated that the documents annexed to this bail petition, Lordship, application are true copies of the original and of copies as might available to or obtained by the petitioner, and as such are believed to be true copies of the original. This is the reason, these are the reason which is supported by a false affidavit, Lordship. This is my submission. The delay of 137 days cannot be condoned, and their petition is liable to be dismissed and appeal is liable to be dismissed, Lordship.
My Lord.
Yes.
My Lord, the fact that the tribunal's order was received lately by the regional office, my Lord. Therefore, the process occurred to be late. And as my learned friend said, my Lord, I have explained it from the day on, my Lord, from 16 to 2024. I apologize before this honorable court for the date, my Lord, in the last line of the paragraph number 4, that should have been 27, my Lord. Because, my Lord, the appeal was filed, my Lord, and due to some technical errors, my Lord, that was registered a little late. That is what this date is by mistake, a typographical error, my Lord. And regarding this affidavit, my Lord, the bail application, that should have been application, my Lord. And I apologize, and if your Lordship directs me, my Lord, I will file another affidavit, my Lord, if it permits, my Lord. But everything here, my Lord, was as per the office process, my Lord. Since the head office is in Mumbai, my Lord, the communication takes a little time. As my learned friend said, yes, it should have been more diligent in doing so. But my Lord, the communication from regional office Gauhati to Mumbai, my Lord, it takes some time, my Lord.
Many orders of this court and other courts also that such communication between regional office, head office cannot be a ground these days, in this day and age. And you have,
my Lord, but
you have been very
the
careless.
certified
Yes.
The certified copy of the order by the Learned Tribunal was obtained a little late by the regional office, and therefore, since the regional office is not the authority to take a decision on its own, my lord, it's the head office who has to give the decision whether to file an appeal against the judgment or not, my lord. And 137 days delay, my lord, I have explained it as a whole, my lord, not only 47 days, my lord. Regarding, my lord, the appeal, my lord, though this honorable court do not go to the effect of the appeal, my lord, there is a sufficient good ground, my lord. If this delay is not condoned, my lord, it will be his loss to the company also, my lord.
Court is not convinced. This is okay. Heard, Miss, you are
S. Kakoti, my lord.
Ms. Kakuti, learned counsel for the appellant, and also Mr. B.N. Sharma and Mr. M.T. Wapang for the respondents number 1 and 2.
Yes, Lordship.
No, respondents 1, 2, 3, 4, I think.
Yes, Lordship.
Yes, respondents
One.
1, 2, 3, 4, please. This application under Section 5 of the Indian Limitation Act has been filed by the appellant slash insurer praying for condonation of delay of 47 days in preferring the accompanying appeal under Section 173 of the MV Act against the judgment and order dated 16/2/2024 in MAC case number 35/2022 passed by the learned MACT Tuensang Nagaland. Stop. The learned counsel appearing for the appellants has submitted that the main grounds for the delay has been set out at paragraph 5 of the application. Stop. It is stated that the engaged counsel of the company was informed about the judgment and order, judgment and award dated 16/2/2024. No, wait. That the engaged counsel of the company informed about the judgment and award dated 16/2/2024 to the company, and accordingly certified copy of the order was sent to the regional office of the appellant company on 26/2/2024. And upon receiving the same, the engaged counsel was requested to send all the papers of the case for future course of action. Stop. Accordingly, the relevant papers were collected from the engaged counsel on 15/3/2024, and it was forwarded to the head office at Mumbai for information and necessary action on 20/3/2024. Stop. On 28/3/2024, the head office at Mumbai directed the regional office to obtain the opinion of an impaneled advocate as to whether there is any scope of appeal or not. Stop. As directed by the head office on 8/4/2024, the relevant papers were forwarded to an impaneled advocate with a request to form an opinion whether there is any scope to prefer an appeal. Stop. It is stated that on 26/4/2024, the impaneled advocate gave his opinion that there is good ground to prefer an appeal against the judgment and order dated 16/2/2024 as 16/2/2024 stop. As there was Bihu holidays in between, and after obtaining opinion from the impaneled advocate, the same was forwarded to the head office only on 10/5/2024. Stop. Thereafter, the matter was processed in the head office, and on 25/5/2024, the matter was remanded to the regional office with the direction to prefer the appeal against the judgment and order dated 16/2/2024. It is stated that as per the direction of the head office, the papers were ultimately sent to an advocate on 7/6/2024 to prepare and file the appeal. Stop. It is stated that this process took substantial time, and in doing so, the limitation period of 90 days expired. Stop. It is also submitted that the engaged counsel finalized the draft of the memo of appeal in the last week of June and sent the draft of the memo of appeal to the regional office for vetting as per the company procedure. Stop. Learned counsel also states that as the office was overburdened, the relevant file was returned only on 29/6/2024. Stop. It is stated that after final settlement of the memo of appeal, the appeal could be filed only on 2/7/2024, and by that time, a delay of 47 days had occurred. Stop. It is stated that there has been no deliberate and intentional delay or negligence on the part of the applicant company, and that every effort has been made by the appellant, but due to reasons beyond their control, the appeal could not be filed within the prescribed period of limitation. Stop. Next paragraph. Learned counsel for the respondents, Mr. B.N. Sharma, opposing the submissions of the learned counsel for the appellant, has submitted that the delay caused in filing the appeal is due to the negligence and lethargy of the appellants. And there is also suppression of material facts. Stop. He has submitted that there is no explanation about when the engaged counsel of the appellant informed about the judgment and award. There is also no explanation as to when the file was forwarded for legal opinion. There is also no explanation as to when the file was handed over to the counsel. Stop. It is also alleged that there was a Bihu festival in between, and that the delay was caused due to this. But the Bihu festival is only from 14th to 16th April, and it was over even before receiving of the opinion dated 26/4/2024. Stop. Even after receiving the papers on 25/5/2024, the file was forwarded to the council on 7/6/2024, that is after 14 days. Stop. Learned counsel also submits that the explanation of delay must be for the whole period and not just for the period after the limitation has expired. Stop. Relying on the case of Sitaram Ramcharan versus M.N. I'll give you this later. Versus M.N. Nagarshana and others, AIR 1960 SC 260 FP, where the Honorable Supreme Court had held that in dealing with the question of condoning delay under Section 5 of the Limitation Act, the party has to satisfy the court that he had sufficient cause for not preferring the appeal or making the application within the prescribed time. And this has always to be understood to mean that the explanation has to cover the whole period of delay. Stop. Learned Counsel also submits on, also relies on an order of this court in IA 147/2024, wherein this court, by order dated 10/3/2025, had observed that the explanation given by the applicant based on administrative formalities and movement of files from table to table are not valid grounds in view of the advancement of modern technology, which allows speedy communication even from far-flung areas. Stop. Learned Counsel also relies on the case of, there are many cases here, you just note down later. After that. In view of the above authorities, Learned Counsel for the respondent prays that the present application may be dismissed and that the delay should not be condoned. Next paragraph. I have considered the submissions of the counsels for the parties and perused the application, application. On going through the same at paragraph 5, where the explanation for the delay has been recorded, stop. This court has observed that the applicant has been negligent and careless in as much as the judgment and the impugned judgment and order date has been given as 31/5/2024 and not 16/2/2024. Stop. Even the date of filing of the present application is recorded as 15/5/2024 and not 2/7/2024. Stop. The reasons for the delay in this case is also the movement of the files from the regional office to the head office and in between the company and their engaged advocate. Stop. There is also no proper explanation in between 26/4/2024 and 10/5/2024. So accordingly, this court is of the view that no sufficient cause has been shown by the applicant and therefore the application is dismissed. No orders as to cause.
Right.
Lordship, in view of the.
Yes, in main case, in view of the order passed in ISM research, the bill is also dismissed.
Lordship.
For hearing, item number 10.
You ready?
Yes, Lordship. My senior will be taking up the matter.
Okay.
Please, Your Lordship. This case has been dragging on for 6 years now.
Yes.
Yes, Your Lordship. And a lot of affidavits have also been exchanged. In the process, certain developments, surprising developments also have taken place. After 5 years of filing the writ petition, some new developments also took place, but that was beyond the control of the petitioner and purely at the negligence of the state respondents. So, my lord, here, though the pleadings have become very huge in the course of the years, I will only try to differentiate between the doctrine of reasonable classification on whether we are actually at par with the Nagaland Police Service or not as per the 1993 ROP rules, which stated categorically that the corresponding service of the Nagaland Village Guards is the Nagaland Police. So we are saying that there is a disparity in the fixation of pay because, my lord,
You are village guards.
we are village guards. We become government servants officially till the rank of Havildar. It is on a voluntary service, like the home guards. But starting from the rank of Jamadar, Subidar, and Subidar Major, it's a government servant. And the next promotion is Assistant Commandant in the rank of DYSP. My lord will appreciate here, before I go into the documents, one simple.
Lordship, I have a prayer.
Yes.
With the leave of the Honorable Court. I have some difficulty today. So since the matter is pending since
2019.
years, so let the petitioner be allowed to be heard today and I may be responded by tomorrow itself.
I'm okay with that,
There's
my
a
lord.
benefit. Long
If my lord allows.
I have some difficulties.
Can we fix it on, his argument, can we take it on Thursday? Because tomorrow I have an urgent matter in another court.
Thursday, I have some appointment in the Gauhati principal bench. So
Oh, okay, then, my lord, let him argue tomorrow.
tomorrow.
It's
I won't
okay.
take much
I'll argue
time.
today, my lord. It's okay.
Let your junior be here.
Yes, your lordship. Unless some replies are necessary, the two main
Then
points,
we'll fix another day. In that case, again, keep it part heard.
my lord, my lord. In fact, the two main points which the state is arguing is, number one is our qualification. Generally, our qualification is below the qualification required for joining the Nagaland Police Service. And the second is that, the second point is that the committee for the Pay and Anomaly Committee had considered this issue way back in 2019. But that I will satisfy your lordship. Those are the two main points of argument for the state respondents.
Ultimately, your prayer is to pay the same pay scale of corresponding ranks in the police department.
Yes, my lord.
As per the ROP rules of 1993.
My lord.
And the state respondents to correct the erroneous pay scale and to pay to the petitioners the consequential benefits of the areas of service.
No, my lord, here, before I go into the documents, just a brief explanation.
Lordship, I may be allowed to leave for today. I have some matter in the court number 1.
Sir. Now, my lord, Jamadar, Subidar, Subidar Major, Assistant Commandant. And in the Nagaland Police Service, Assistant Sub-Inspector, Sub-Inspector, Inspector, and Assistant Commandant or DYSP or Subdivisional Police Officer. In the rank of the Assistant Commandant and the DYSP, the pay scale, everything is same. But starting from the rank of Jamadar, Subidar, and Subidar Major, which is in the corresponding rank of Assistant Sub-Inspector, Sub-Inspector, and Inspector, at least I would say that it's not a matter of admission, but I feel that if assuming that they cannot be given the same pay scale, at least in the rank of Subidar Major, there appears to be some level of fairness because the Subidar Major is paid the pay scale of Sub-Inspector. But in the two lower ranks, the disparity of pay scale, my lord, is it's a human goes, and even from a, not arguing as a lawyer, but even from a layman point of view, it's extremely unfair because the Jamadar that is in the rank of assistant sub-inspector is paid the pay scale of a constable, your lordship.
You have service rules.
No, unfortunately, we have no service rules. Then, my lord, the next rank, Subidar, which is in the rank of sub-inspector, it is paid the pay scale of 2 Pitas Naik. So, my lord, even assuming that because of the difference in the qualification that the entry level that is in the rank of assistant sub-inspector, sub-inspector and inspector, even assuming that because of the want of qualification, regardless of the dangerous duty that the Nagaland village guards perform, which is much more dangerous than Nagaland police, and there is no extra incentive for the dangerous service that they provide also. So, my lord, the pay scale, if the assistant sub-inspector was paid the pay scale of a Havildar, which is also one rank down, then at least we would say that, okay, some fairness is there. Or in the rank of the Subidar, which is in the rank of sub-inspector, if he is paid the pay scale of assistant sub-inspector, like the Subidar major in the rank of inspector is paid the pay scale of a sub-inspector, then the argument would have been weakened, my lord. But here in this case, the pay scale disparity, it is so huge that the very language that home guard or the village guards are a corresponding service to the Nagaland police as per the ROP rules of 1993. My lord, the word corresponding cannot mean that one is in Jaffa Mountain and one is at the banks of Doyang River. That is the difference of the pay scale, my lord. So, my lord, that is why we have approached this Honorable Court. And in the process of this litigation, 3 of the petitioners have already been promoted to assistant commandant. My lord, shall we go to the 1993 ROP rules? I want to make my submission short, brief, and crisp as much as possible, my lord.
Relying on the ROP rules.
Yes, my lord. We have a copy for the court. My lord, the first page, it is at page 141 at the bottom.
So, or you're reading.
Yes, page 141. Bottom page, page 141. Has my lord seen? On the top, it is 51 village guards. Then the noting on the side will be entitled to same pay scale as recommended for corresponding ranks in the police department. Now, what does it mean by corresponding ranks, my lord? It is the contention of the state respondents, my lord, that corresponding ranks means the Jamadar is in the rank of constable. So from constable, it goes to, if we have to go by the interpretation of the state respondents, from constable, you go to Naik, and from Naik, you get direct promotion to inspector. Because while filing this writ petition, I was of the impression that there is no ambiguity at all, corresponding ranks. And what cannot be disputed, my lord, is that corresponding ranks, 3 ranks, assistant sub-inspector, Subidar, assistant sub-inspector, Jamadar, assistant sub-inspector dash Jamadar. Yes. Then sub-inspector and Subidar. Subidar. Inspector and Subidar major. And the next is assistant commandant slash DYSP SDPO. There the pay scale, everything is same, my lord.
when you reach Assistant Commandant, the YSB is
Yes,
the same.
it's the same. If they say that this corresponding rank will not apply at all in the lower three ranks, then the pay scale should be different in the rank of Assistant Commandant or DYSP or SDP also, my lord. But there the pay scale, everything is same. My lord, on the basis of this, initially, there were many representations submitted. My lord. Now, many representations were submitted, but my lord, as my lord is aware, a lot of litigants, they don't keep their copy with them. And the first copy that they could trace in their possession was way back only in 2008. If not after the coming of the ROP rules 1993, they have submitted many representations, and the office also maybe they did not take sincere consideration of those representations, so it could not be traced out in the office of the Commissioner Nagaland also, or in the lower offices of the Commandant, Deputy Commandant, Assistant Commandant, and all. It could not be traced. The first copy that could be traced is of 2008, my lord. Now, my lord, the nature of duties performed by this Nagaland police and then the village guards. This Honorable Court wanted to know what kind of duties we perform, so we filed an affidavit, additional affidavit. When did we file?
28 April.
17 April. Oh, yes, Your Lordship. 17th of April, 2022. So it must be filed somewhere around 18th of April, my lord. Additional affidavit by the petitioners.
Filing of additional documents in the additional.
Yes, Your Lordship. Yes, my lord. Here, my lord, we may not go into the details, but Your Lordship, basically what we are trying to, we try to establish by way of filing the additional documents is the nature of duties that we perform, which is largely close to the duties which is performed by Nagaland police. In the human dwelling areas like towns or rural areas, my lord, we'll see that when the army, Indian Army, they perform duties, they're actually escorted and led by the Nagaland police. In the international border areas, even now these days, it's all in the video, so I hope it will not be misinterpreted because people can also see. But even in the areas where even the Indian Army Jawans are afraid to venture into, it is the Nagaland village guards who take the risk, and they know the areas at the back of their hand. They're the ones who perform the most dangerous duties in the international border also, my lord. And besides that, my lord, there are some areas where there are no police station, where I have mentioned the 2 or 3 places. Para 26, my lord. Para 26. May I read, my lord? Under the district of Noglak and Kifri, in the following locations, there are no police stations and only village guards operate. Under Noglak district, Pangsha Trade Center and ESC Post, Noku ESC Post, Longnok Outer Edge, Indian Myanmar Way, Kinjong, Chipur, and Tongsonyu Village, 139 pillar. The 139 pillar is the name of the pillars in the international borders, my lord. India-Myanmar border under Noglak district, and under Kifri district, Khonsa ESC Post, Kyusam ESC post, Sitim ESC post, Amahator ESC post, and Longmatra ESC post. This was in 2022, so I do not know the latest status on where presently any police station has been set up in any of these areas or not. But as on date of filing this affidavit, there was no police station, and it was the Nagaland village guards who were running this like the normal Nagaland police stations, my lord. Then, my lord will kindly come to page 49, annexure 26. Some of the accolades and achievements of the Nagaland village guards. May I take a lordship to the relevant page, page 53. Page 53. This is the last page, my lord. So, Ashok Chakra, class 2. There are 7 Ashok Chakras, Kriti Chakra 2, Ashok Chakra 3, 5 of them, Shaurya Chakra, 9 of them, Governor Medal 1, Governor Commendation Certificate 13. So, my lord, even in terms of the meritorious service, if we look at the meritorious service, we're not looking down on any other services because every service offers their own specialty in their own area. But if you look at the meritorious achievements of the service of the Nagaland village guards, in fact, in comparison with the Nagaland police, they are nowhere near the achievements of the Nagaland village guards, with so many Ashok Chakras, Shaurya Chakras, and other chakras, and governor's certificate, commendation certificate, and governor medal also, my lord. Your lordship, going by all these achievements of the Nagaland village guards, it is very unfair that when the language in 1993 ROP rules is corresponding ranks. Now, corresponding ranks, if, my lord, just for the sake of academic understanding, if there were more ranks in the Nagaland village guards before reaching the assistant commandant, starting from the rank of Jamadar, then the issue would have been different. But here, the corresponding ranks, 3 ranks in the Nagaland village guards also, 3 ranks in the Nagaland police also, next promotion to the rank of assistant commandant, my lord. I would respectfully say that the state has not applied their common sense and a reasonable mind in determining the pay scale and the pay grade of the Nagaland village guards, my lord. Is it time for your lordship to take medicine?
5 minutes.
My lord.
Yeah.
My lord,
Yes.
may I now take your lordship to the representation of the petitioners at page 142. Page 142, annexure 104 of the writ petition, my lord. Your lordship, after the ROP rules of 2017, we submitted this representation. I'm not going into other representations, my lord, just to show your lordship on what was the next development.
And after this 93, what you were saying only one representation.
No,
After
there-
93
there are-
ROP?
yes, my lord, the first representation is 2008. I will show your lordship.
Why only in 2008?
No, my lord, there were other representations also, but unfortunately,
Cannot trace them.
they did not keep an extra copy for themselves. And I asked them to trace the representation even from the offices also. But it has been many years. So the offices are not like a court which keeps record like us. So no representation could be traced out. Only the copy which was with them at page 126, my lord, annexure 93. Page 126. This is the first representation that was traced out. No. Okay. Seven 1/2008. After this, there are several representations, my lord, and correspondences were also kept on record by the petitioners. Perhaps the first office bearers were not as diligent like the one who took the office in 2008. Then, since, my lord, if we are looking at the representations, may I take your lordship also to page 134. This is from the Office of the Commissioner, Nagaland.
And what were the replies given to these representations?
So, my lord, in the process of the files being processed and pursued by the members of the Petitioners Association, my lord, this is one of the forwarding letters which is forwarded by the ADC, Additional Deputy Commissioner, Office of the Commissioner, Nagaland, to the Home Commissioner at page 134, my lord, Annexure 98. May I read, my lord?
Yes.
It's a short representation.
Street.
Letter number so and so, dated 9th November 2015 to the Home Commissioner, Nagaland. Subject: proposal for enhancement of pay scale for revision of pay scale, JCOs under junior commission officers under village guards organization. Sir, in inviting a reference to the subject cited above, I am directed to submit herewith representation received from the village guards JCOs on the subject cited above, and to state that the village guard Subidar Major is equivalent to the rank of inspector in police department, while Subidar VG is equivalent to sub-inspector Nagaland Police, and Jamadar VG is equivalent to the rank assistant sub-inspector in Nagaland Police Department. However, it is observed that the pay scale of these two categories of the post is different, from which the JCOs under the village guards organization is submitting a demand for enhancement of their pay scale as per Finance Department notification so and so. That is the rules of 1993, ROP rules 1993, 25/11/1993. As mentioned below, a chart showing for difference in pay scale is elaborated for comparison. Then below the chart, my lord is reading the chart.
Subidar and Jamadar, only the grade pay is different. Otherwise, it's 5,200, 5,200. Grade pay only the police, Nagaland Police is higher.
Your lordship, the grade pay.
Of course, for inspector, there is a vast difference. But for Subidar and Jamadar, grade pay.
Grade pay, your lordship. The grade pay of Jamadar, the grade pay of a Jamadar is in the grade pay of a constable. I've prepared a chart in my writ petition, your lordship, for easy reference, which is not disputed by the state respondents also. Page.
Where is it?
May I take your lordship to page 24 of my writ petition. Para 61. May I read, my lord? Paragraph 61. 59. Oh, it will start from para 59, my lord. The 3 ranks. Paragraph 59. That is the Jamadar. May I read, my lord?
You should have made a table for easy understanding. Anyway.
Yes, your lordship. May I read, my lord?
Yes.
Para 59. That as per the Nagaland Service Revision of Pay Rules 1993, hereinafter referred to as the ROP Rules 1993, the scale pay of the Assistant Sub-Inspector of Police was revised from 510-895 to 1250-2280, whereas the corresponding rank in Village Guard Jamadar's pay at 400-690 was revised to 91760. The Jamadar of Village Guard, which is equivalent to the rank of Assistant Sub-Inspector hereinafter referred to as ASI, was paid the salary of a constable in police. As per the ROP rules of 1993, the constable's pay was revised from 400 to 690, which is equivalent to Jamadar, my lord, to 91760. The Jamadar's pay scale, my lord, is in the rank, paid the pay scale of a police constable. Then, my lord, the next ROP rules of 1999, my lord, the next sub-para, the pay scale of sub-inspector at 612.75 was revised to 1450.2840. Whereas the scale pay of Subedar Village Guard, which is in the equivalent rank, was revised to 1,018.80. The scale pay of Subedar is fixed in the pay scale of Naik. Yes, Your Lordship. This is the Subedar, Sub-Inspector Subedar, at the equivalent rank of Naik, 2 stripes in Nagaland Police, though the Sub-Inspector in the Subedar of equivalent rank. Then, my lord, the scale pay of Inspector, the third sub-para, my lord, at 1605 was revised to 1650.3475. Whereas the scale pay of Subedar Major in the equivalent rank was revised from 612.75 to 1450.2840. The scale pay of Subedar Major is also fixed a step lower, though the Subedar Major is in the equivalent rank of Inspector of Police. Then, my lord, the paragraph 60, that is in the next ROP of 1999, my lord. Married, my lord. As per the Nagaland Service Rules of Pay Rules, Service Revision of Pay Rules 1999, referred as Rules of 1990, ROP Rules 1999, the scale pay of Assistant Sub-Inspector of Police was revised from 1250.2280 to 4,100, 6,000. Whereas the corresponding rank in the Village Guard Jamadar's pay at 917.60 was revised to 22,750, 70, and 3,875, 4,400. The Jamadar of Village Guard, which is equivalent to the rank of Assistant Sub-Inspector, was paid the salary of a constable in police as per ROP rules of 1999. The constable's pay was revised from 917.60 to 2750, 70, 3,875, 4,400. Your Lordship, the pay scales in this, I'm reading out, but it is ditto. Ditto starting from 1993 till today, my lord. The scale pay of sub-inspector at 1450, 2840 was revised to 4,500, 125, 7,000. Whereas the scale pay of Subedar Village Guard, which is in the equivalent rank, was revised from 1,000, 1880 to 3,050, 75, 39, 50, 80, 45, 90. The scale pay of Subedar is fixed at the equivalent rank of Naik, 2 stripes in police department, though the sub-inspector and the Subedar are of equivalent rank. Then the scale pay of inspector at 1650, 3,475 was revised to 6,175, 7,750, 200, 9,750. Whereas the scale pay of Subedar Major in the equivalent rank was revised from 1450, 2840 to 4,500, 125, 7,000. The scale pay of Subedar Major is also fixed a step lower, though the Subedar Major is in the rank of Inspector of Police. Then 61, my lord, this is ROP rules of 2010. My lord, shall I read or?
You just read.
Okay, my lord. That as per the Nagaland Service Revision of Pay Rules 2010, hereinafter referred to as ROP Rules 2010, the scale pay of the Assistant Sub-Inspector was revised from 4,100, 6,000 to 5,200, 20,200 in the grade pay of rupees 2,400. Whereas the corresponding rank in the village guard, Jamadars pay at 2,750, 2,750, 70, 3,800, 75, 4,400 was revised to 5,200, 20,200 in the grade pay of 1,800. So the grade pay difference is 2,400 and here we are 1,800. The Jamadar of village guard, which is equivalent to the rank of assistant sub-inspector, was paid the salary of a constable in police. As per ROP rules 2010, the police constable was revised, pay was revised from 2,750, 70, 3,800, 75, 4,400 to 5,200, 20,200 in the grade pay of 1,800. The scale pay of sub-inspector at 4,500, 125, 7,000 was revised to 5,200, 20,200 in the grade pay of rupees 2,800. Whereas the scale pay of Subidar, village guard, which is in the equivalent rank, was revised from 3,050, 75, 3,950, 80, 4,590 to rupees 5,200, 20,200 in the grade pay of rupees 1,900. So which is, there is a difference of 900 rupees in the grade pay, my lord. The scale pay of Subidar is fixed at the equivalent rank in the police department below the grade pay of Havildar, though the sub-inspector and the Subidar are of equivalent rank. Then the scale pay of inspector at rupees 6,175, 7,750, 200, 9,750 was revised to 9,300, 34,800 in the grade pay of rupees 4,400. Whereas the scale pay of Subidar Major in the equivalent rank was revised from 4,500, 125, 7,000 to 5,200, 20,200 in the grade pay of 2,800. So my lord, the grade pay difference is also even in between the Subedar Major and then the inspector. It's quite huge, 4,400 and 2,800. Then my lord, para 62. That as per the Nagaland Service Revision of Pay Rules 2017, the scale pay of the Assistant Sub-Inspector of Police was revised from 5,200, 20,200 in the grade pay of rupees 2,400 to the grade pay of 25,300, whereas the corresponding rank in the village guard Jamadar's pay at rupees 5,200, 20,200 in the grade pay of rupees 1,800 was revised to the grade pay of 18,000. So, my lord, the difference is 18,000 and 25,300, my lord, in the corresponding rank. The difference is quite huge. The Jamadar of the village guard, which is equivalent to the rank of assistant sub-inspector, was paid the salary of a constable in police. As per the ROP rules of 2017, the police constable was revised from pay was revised from 5,200, 20,200 in the grade pay of rupees 1,800 to the grade pay of 18,000. Same with the Jamadar, my lord, constable. The scale pay of sub-inspector at 5,200, 20,200 in the grade pay of rupees 2,800 was revised to the grade pay of 28,700. Whereas the scale pay of Subidar village guard, which is in the equivalent rank, was revised from 5,200, 20,200 in the grade pay of rupees 1,900 to the grade pay of rupees 19,500. So my lord, here also the difference is quite huge, 19,500 and 28,700. The scale pay of Subidar is fixed at the equivalent rank of DR in police department. What was DR?
What is DR?
Your Lordship, it's just equivalent rank. I forgot now. My apologies, Your Lordship. though so my lord, a rank below the Havildar is two stripes, Naik. There's a huge difference, my lord. I have already stated, but 19,500 and 28,700. It's quite huge, my lord, for a corresponding rank. The scale pay of inspector at rupees 9,300 to 34,800 in a grade pay of rupees 4,400 was revised to the grade pay of 40,800. Whereas the scale pay of Subedar Major in the equivalent rank was revised from 5,200, 20,200 in the grade pay of 2,800 to the grade pay of 28,700. So my lord, we'll also see the huge difference here. The equivalent rank in the police is enjoying 40,800 grade pay, whereas the Subedar Major in the Nagaland Village Guards is enjoying 28,700. The scale pay of Subedar Major is also fixed a step lower, though the Subedar Major is in the equivalent rank of Inspector of Police. So my lord, here, before I take your lordship to again the Annexure 104, what I would like to impress before this honorable court is the state, unfortunately, I do not know whether I'll be available tomorrow when my learned senior colleague will be arguing. But basically, the two stands which is strongly taken by the state respondents is that our qualification at the entry of the service. Many of us, of course, some of us, we have entered in the rank of Jamadar directly also. But many of us have come by way of promotion from the voluntary service, from constable to 1 Pita, 2 Pita, 3 Pita, and then that's how we got promoted also. Lord, the entry level qualification, even assuming that, though not admitting, even assuming that that would give an edge to the state respondents, at least the disparity should not be as vast when they are said to be in the corresponding ranks. We know that we are from the different department.
What is your entry level qualification?
Your lordship, for now, all those who have received promotion, all of them are graduates. But my lord,
But Jamadar at the entry level of Jamadar?
yes, your lordship. So,
What is
but
the
then,
qualification?
see, there is no specific service rule as such. But then, according to the state respondents, and then they are the ones, they are the employers. So, I could not refute it for the fact that apparently some of us were class 12 pass. But my lord, if we go back many years back, even in Nagaland police also class 10 pass and class 12 pass, and over the years there has been enhancing, your lordship. But then that is the stand of the state respondents. That
Class 12. Class 12 pass.
yes. Apparently that was the requirement when we were recruited. Whereas for the Nagaland police, it should be compulsory graduate. Even then, my lord, my argument on that point is on twofold. Number one, my lord, in other services, forget about Nagaland police and then the village guards. For instance, I am a diploma holder and somebody is a degree holder, but especially in the engineering service, one who has come up by way of promotion, just because he is a diploma holder does not mean that he is given a lower pay scale. In the same rank, people enjoy the same pay scale. The only difference is that here, we are from different departments. So I cannot say that the same principle should strictly apply. I'm not saying that, but just for a matter of understanding from the common people's point of view also. My lord, here, if we have to look at the dangers of the duties that the Nagaland village guards have been performing and the meritorious service that they have been rendering over the years, even assuming that our qualification at the entry, some of us some of us may have a qualification at the entry level and the Jamadar level may be lower than the Nagaland police. But whether that argument gives the right to the state respondents to treat a corresponding rank in another service in such a manner that one is enjoying the pay scale of a assistant sub-inspector and in the corresponding service in the same level, the same corresponding rank is given the pay scale of a constable, which is 4 steps lower in the grade pay. My lord, see, if we have to count, constable, Lens Naik, one pita is Lens Naik, constable, Lens Naik, Naik, Havildar, assistant sub-inspector. Yes, so it's 4 ranks down. So I do not know what kind of logic the state respondents have used. And I would respectfully say that it is highly demeaning and unfair. And even under the doctrine of reasonable classification on the principle of equity, whether the action of the state respondents meets the criteria under the principle of equity, the treatment given to the Nagaland village guards, it is highly demeaning and it looks down upon the meritorious service that the members of the service have been rendering to the state and the country over the years and decades. Then, my lord, after the next point, my lord, after we filed this writ petition, April 2019, we filed this writ petition, and then we wrote a representation dated signature date, my lord, is 21/6/2018. At page 142, my lord, annexure 104. We wrote this representation to the Chairman Pay Anomaly Committee.
This is when?
21/6/2018, my lord. After the ROP rules of 2017, the state respondents, they gave this notification. My lord, may I take your lordship back again to page 140? 140. A notification was issued to the effect that anyone who is aggrieved by the ROP rules of 2017 were directed to submit a representation.
Page
140, my lord, annexure 103. May I read, my lord? Notification dated Kohima, 1st June 2018, Government of Nagaland, Office of the Pay Anomalies Committee, Nagaland, Kohima. This is for general information to all the departments and service associations / individuals that the Government of Nagaland have constituted a Pay Anomalies Committee wide notification number so-and-so dated 21st May 2018 for examination of pay anomalies, if any, arising out of the Nagaland Services Revision of Pay Rules 2017. The committee has been given 4 months' time effective from the date of its constitution to submit its recommendation to the government. To enable the committee to proceed with its task, all the state government departments and service associations, including individuals, are hereby informed to submit their representations, if any, clearly indicating the anomalies, if any, found by them in the Nagaland Service Revision of Pay Rules 2017 as to reach this committee latest by 15 July 2018. All such representations should be addressed to the Chairman, Pay Anomalies Committee, and sent to the official address of the undersigned. So latest by 15 July 2018, we were directed to file the representation. So we filed it on 21/6/2018, my lord. So, my lord, there was no reply whatsoever from the Pay Anomaly Committee or the department, my lord. So we filed this writ petition in the month of April 2019, my lord.
after submitting the representation.
Yes, after submitting the representation on 21/6/2018, we approached the state respondents on several occasions to consider our representation, but there was no whisper whatsoever from the pay anomaly committee also, from the state respondents also, my lord. So we filed this writ petition on 9/4/2018, my lord. It was filed on 19, my lord, on 9/4/2019, my lord, my apologies. 9/4/2019. And the motion, it was listed on 10/4/2019. The state respondents filed their affidavit in opposition. The state respondents. When is the date?
1 to 7.
Yes, your lordship, 1 to 7. When did you file? Oh, no, 9th of February 2021.
21.
Oh, my lord, when they filed this affidavit, after nearly 2 years, even in this affidavit, my lord, no whisper whatsoever, no information that our representation was considered by the pay anomaly committee. Then, my lord, on my insistence, in fact, when the matter was taken up before His Lordship Justice Devashish Barua, he said he wants to refer the matter to pay anomaly committee. Then I said, no, my lord, now we are before this honorable rate court, having extraordinary jurisdiction to interfere into the matter if fairness, in the opinion of the court, is not being applied. Then this court is the right jurisdiction to try this matter. And I'm not in favor of the matter being referred to the pay anomaly committee because we have already written a representation and nothing came about it. Then, my lord, in the course of the discussion.
Normally, when the associations submit these representations,
Yes, my lord.
they are summoned actually by the pay anomalies committee for discussions.
Yes, your lordship.
Yes.
But
So that means you were never called also.
no, we were never called. We did not even know that the pay anomaly committee decided the issue. But, my lord, in the course of the Learned Counsel for the state respondents, asking from the department again and again on what has happened, your lordship, by the affidavit, additional affidavit that we received on 10/9/2024, that is after 5 years, my lord. And next year, we receive on 10/9/2024, whether, my lord, in your copy, it may be 8 or 9 of September 2024.
Additional affidavit
Yes, my lord.
filed on 3rd September 2024.
Oh, my lord. Based on the order passed by His Lordship, Mr. Justice Nelson Silo.
Yes, the order dated 24/6/2024.
Yes, your lordship. My lord, surprisingly, a copy, report of the Committee on Pay Anomalies, page 25, my lord.
Wait, anyway, what did this court say?
My lord.
Petitioner should contain as to what happened to the representation
Yes, your lordship.
submitted by the respondents. If the same has been considered, the outcome of the consideration should be reflected such and such. Okay. Then after that, they filed this affidavit.
Another order was also there, my lord, but it's just a continuation of the earlier order.
The order of 28.
Yes, my lord. Then annexure 3, my lord, page 25. May I take your lordship to the relevant page, page 32, last page. The last page of the additional affidavit. My lord, here, B, comments on the committee, the village guards. Here, they have not mentioned the rank of They have not mentioned the rank of Jamadar. They just mentioned two ranks, Subedar and Subedar Major. Comments of the committee. As regards the demand of JCOs of village guards, it may be observed that equating Jamadar, Subedar, and Subedar Major with ASI, SI, and Inspector in police department may not be tenable. Village guards cannot be equated with civil police. The village guards are paid fixed wages. Only Jamadar, Subedar, Subedar Major, Assistant Commandant, Deputy Commandant, and Commandant are getting pay scale of ROP. From ROP 1999, it may be seen that Subedar Major, Subedar, and Jamadar are getting pay scale at par with the Sub-Inspector, Naik, and Constable. Now, there's an admission here also, my lord. The Sub-Inspector, Naik, and Constable in Police Department. The corresponding pay band and grade pay were given to them in ROP 2010, and a pay scale and a pay level under ROP 2017 also corresponds to the same. As such, there is no justification in a demand. So, my lord, here, what I would like to impress upon your lordship for your lordship's consideration for application of a judicious mind in these cases. 2 points, my lord. Number one, we were never informed or summoned at any point of time about this report of the anomaly committee, though the writ petition was already filed on 9th of April 2019. And this affidavit, according to your lordship's copy, it was filed on 3rd of September 2024. We received the same copy on 10th of September 2024. So why this committee report was hidden from us all these years and was presented before this honorable court after 5 years of filing the writ petition before this honorable court? In fact, there is no date as such also on when this pay anomaly committee report was published. No date also, my lord. If I'm not wrong, my lord, I have gone through it and I didn't see on which date it was published. So the one question that lingers on is whether after filing this writ petition, without putting any date, they have to pretend to show that our representation was rejected, so that our petition pending before the Honorable Court will be hijacked.
From 99, ROP 99, it may be seen that Subedar Major, Subedar, and Jamadar were getting pay scale at par.
Yes, at par with Sub-Inspector, Naik, and Constable.
They are saying that you're getting the same.
No, that's why. At par with the Sub-Inspector, that is a rank, yes, Naik and Constable. So the language at par, my lord, it appears to show as if Subedar Major is enjoying the pay scale of Inspector.
That's right.
But in the next continuing sentence, Sub-Inspector, Naik, and Constable.
Oh, okay, okay.
Yes, your lordship.
Getting pay scale at par with that of Sub-Inspector, Naik, and
My lord, your lordship.
the corresponding pay band and pay scale were given to them in ROP.
Now, my lord, considering the fact, in continuation of my argument on this point, my lord, considering the fact that this very document was not even given to the petitioners, but by way of additional affidavit was brought before this Honorable Court after 5 years of filing the writ petition. The question now comes, which I believe is covered by the settled position of law, that when the fault is not attributable to the petitioner or the applicant, then the Honorable Court is to mold an exceptional relief We have the judgment also, yes. An exceptional relief has to be molded by the Honorable Court in favor of the petitioner or applicants. We will go ahead. And I will present the judgment also before your lordship. Because the whole purpose of approaching this Honorable Court would be defeated if same kind of practice is to be not interfered with by the Honorable Writ Court. Then, my lord, the cause of justice will be defeated every time this kind of tactic would be used by the state respondents, my lord. May I now go to the authorities, my lord? Your lordship, 2008 5 SCC 287. I'm relying on paragraph 18, my lord. Satyawati Sharma versus Union of India. This is on the doctrine of reasonable classification, my lord. May I read, my lord? Paragraph 18.
5 SCC 287. Yes. Para?
18, my lord. Paragraph 18. Which is at page 308. Paragraph 18 is at 308.
Yes.
May I read, my lord? In Muhammad Shujat Ali versus Union of India, the court observed that Article 14 ensures to every person equality before law and equal protection of the laws. However, the constitutional code of equity and equal opportunity does not mean that the same laws may be applied to all the persons. It does not compel the state to run all its laws in the channels of general legislation. It recognizes that having regard to the differences and disparities which exist among men and things, they cannot be all treated alike by the application of the same laws. To recognize marked differences that exist, in fact, is in living law. To disregard practical differences and concentrate on some abstract identities is lifeless logic. The legislature must necessarily, if it is to be effective at all in solving the manifold problems and continually come before it, enact special legislation directed towards specific ends, limited in its application to special classes of persons or things. Indeed, the great part of all legislation is special, either in the extent to which it operates or the objects sought to be attained by it. At the same time, the court cautioned against the ready-made invoking of the doctrine of classification to ward off every challenge to the legislative instruments on the ground of violation of equality clause and observed. 24. The equal protection of laws is a pledge of the protection of equal laws, but laws may classify. And as pointed out by Justice Brower, the very idea of classification in that is that of inequality. The court has tackled this paradox over the years, and in doing so, it has neither abandoned the demand for equality nor denied the legislative right to classify. It has adopted a middle course of reasonable reconciliation. It has resolved to the contradictory demands of legislative specialization and constitutional generality by a doctrine of reasonable classification. This doctrine recognizes and that the legislature may classify for the purpose of legislation, but requires that a classification must be reasonable. It should ensure that persons or things similarly situated are all similarly treated. The measure of reasonableness of a classification is the degree of its success in treating those similarly situated. A reasonable classification is one which includes all persons or things similarly situated with respect to the purpose of the law. There should be no discrimination between one person or thing and another if, as regards the subject matter of the legislation, their position is substantially the same. This is sometimes epigrammatically described by saying that the constitutional code of equality and equal opportunity requires is that among equals, the law should be equal, and that like should be treated alike. But the basic principle underlying the doctrine is that the legislature should have the right to classify and impose special burden upon or grant special benefits to persons or things grouped together under the classification, so long as the classification is of persons or things similarly situated with respect to the purpose of the legislation, so that all persons or things similarly situated are treated alike by law. The test which has been evolved for this purpose is, and this test has been consistently applied by this court in all decided cases since the commencement of the Constitution, that the classification must be founded on an intelligible differentia which distinguishes certain persons or things that are grouped together from others, and that differentia must have a rational relation to the object sought to be achieved by the legislation. My Lord, this judgment I'm relying upon because of the 1993 ROP rules, which says that we are entitled to corresponding ranks pay scale. May I continue, my Lord? We have to constantly on our guard to see that this test, which has been evolved as a matter of practical necessity with a view to reconciling the demand for equality with the need for special legislation directed towards specific ends necessitated by the complex and varied problems which require solution at the hands of the legislature, does not degenerate into rigid formula to be blindly and mechanically applied whenever the validity of any legislation is called in question. The fundamental guarantee is of equal protection of the laws, and the doctrine of classification is only a subsidiary rule evolved by courts to give a practical content to that guarantee by accommodating it with the practical needs of the society, and it should not be allowed to submerge and drown the various guarantee of equality, precious guarantee of equality. The doctrine of classification should not be carried out to a point where instead of being a useful servant, it becomes a dangerous master, for otherwise, as pointed out by Chandrachud, and so, the guarantee of equality will be submerged in class legislation masquerading as laws of equality, masquerading as laws meant to govern well-marked classes characterized by different and distinct attainments. Overemphasis on the doctrine of classification or an anxious and sustained attempt to discover some basis for classification may gradually and imperceptibly deprive the guarantee of equality of its specious content. That process would inevitably end in substituting the doctrine of classification for the doctrine of equality. The fundamental right to equality before the law and equal protection of the laws may be replaced by the overworked methodology of classification. Our approach to the equal protection clause must therefore be guided by the words of caution. My Lord, that's it. My Lord, here, when the ROP rules, my Lord, that is part of the rules are part of the legislation. So when the legislation says that entitled to corresponding ranks, in any case, my Lord, I'm sorry, I'm just repeating myself, but in any case, the corresponding rank has to be seen directly next to each other and not in a manner like you take one corresponding rank from the top and then one from the bottom. That is the interpretation of the state. Hence, I'm relying on this judgment. And my Lord, the 2014 8 SCC, 2014 8 SCC, page 682. 682. I'm relying on one paragraph, my Lord. Para 44. Subramanian Swamy versus CBI, my Lord. It's a short paragraph, my Lord.
Para 42.
44, my Lord. 44. Lord, this is, if the object is to discriminate against one section of the minority, the discrimination cannot be justified on the ground that there is a reasonable classification. May I read, my Lord? Para 44, 718 page. That is, para 44 is in 718. in Vithal Rao, the 5-judge Constitution bench had an occasion to consider the test of reasonableness. Under Article 14 of the Constitution, it noted that the state can make a reasonable classification for the purpose of legislation. That the classification, in order to be reasonable, must satisfy 2 tests. 1, the classification must be founded on intelligible differentia. And 2, the differentia must have a rational relation to the object sought to be achieved by the legislation in question. The court emphasized that in this regard, object itself should be lawful and it cannot be discriminatory. If the object is to discriminate against one section of the minority, the discrimination cannot be justified on the ground that there is a reasonable classification because it has rational relation to the object sought to be achieved. My lord, here on this point, the argument of the state would be generally our qualification is not in the rank. Yes, your lordship. But my submission is whether the difference, the huge difference, whether that is reasonable or not. That is my question, my lord. Your lordship, the next is 2013-11 SCC. 2013-11 SCC, page 451. Para 27, I'm relying only on one paragraph, my lord. Para 27. Rohitash Kumar versus Om Prakash Sharma. Para 27, my lord. It's also a short paragraph.
2013-11 SCC.
11 SCC, 451. Para 27, my lord. Para 27 is at page 460, my lord. May I read, my lord?
Yes.
This is on the addition and subtraction of words. Para 27. The court has to keep in mind the fact that while interpreting the provisions of a statute, it can neither add nor subtract even a single word. The legal maxim, a verbis legis non est residendum, means from the words of law, there must be no departure. I'm talking about the interpretation of the 1993 ROP rules, the corresponding ranks. A section is to be interpreted by reading all of its parts together, and it is not permissible to omit any part thereof. The court cannot proceed with the assumption that the legislature, while enacting the statute, has committed a mistake. It must proceed on the footing that the legislature intended what it has said, even if there is some defect in the phraseology used by it in framing the statute, and it is not open to the court to add and amend, or by construction make up for the deficiencies which have been left in the act. The court can only iron out the creases, but while doing so, it must not alter the fabric of which an act is woven. Basically, that's it, my lord. So if we have to go by the literal interpretation, the state cannot bring an excuse of corresponding ranks of a different nature. Then, my lord, 2015 4 SCC 421, page 421. I'm relying on para 17. Two 2015 4 SCC 421, para 17. This is also a short paragraph, my lord. May I read, my lord?
Yes.
This judgment has been subsequently followed by the High Court of Australia in Project Blue versus Inc. versus Australian Broadcasting Authority in the following terms. A legislative instrument must be construed on a prima facie basis that its provisions are intended to give effect to harmonious goals. Intended to give effect to harmonious goals. Where conflict appears to arise from the language of particular provision, the conflict must be alleviated so far as possible by adjusting the meaning of the competing provisions to achieve that result which will best give effect to the purpose and language of those provisions while maintaining the unity of all the statutory provisions. Reconciling conflict provision will often require the court to determine which is the leading provision and which the subordinate provision and which must give way to the other. Only by determining the hierarchy of the provisions will it be possible in many cases to give each provision the meaning which best gives effect to its purpose and language while maintaining the unity of the statutory scheme. So, my lord, here in this case, of course, the State Council is not here, but we are conflicting on the ranks. They are not disputing that from Jamadar, Subedar Major and Assistant Commandant. They are not disputing that, but they want to say that Jamadar is equivalent to Constable.
They are saying that Jamadar is equivalent to Constable.
Yes. So, my lord, here the harmonious goal is that is the responsibility of the Honorable Court to see whether it is the legislative intent to show that corresponding ranks means from Jamadar, you can be equated to Constable. From Subedar, you can be equated to Naik. And from Subedar Major, you jump all the way to Sub-Inspector or Inspector, my lord. So that, whether that argument is reasonable or my argument is reasonable is what my lord is going to determine here.
That is the problem, because you don't have service rules. So, okay, they may be saying that Subedar Major is not the equivalent of inspector.
Yes, my lord.
So they have to show from certain documents or, and at the time of appointment, what does it say, your appointment orders?
Yes, it is.
How will the court
And
decide
those things
that is
are,
the equivalent post?
these are state properties. So the state could have produced those things, but they're just putting an argument saying that we are not of equivalent rank. No, my lord, here.
Because in the ROP, it says Subedar Major Jamadar.
Yes, your lordship.
So from here, we cannot say that this is equivalent to inspector or sub-inspector.
Except from the letter of the ADC, which my lord has already seen from my writ petition, my lord, unfortunately.
They are only forwarding your.
Yes, your lordship. But that is also part of the language which is already adopted by the state respondents also, not the decision-making authority. But my lord, what I would impress upon this Honorable Court for kind consideration is, when we say corresponding ranks, then it has to be, there should be uniformity also, it has to be harmonious also. Harmonious will have other reasons, meaning also, but uniformity, as far as uniformity is concerned, Jamadar, Assistant Sub-Inspector, Subedar, Sub-Inspector, Subedar Major, Inspector. What is the next promotion? Same rank, same pay scale. Now, it is more on the application of mind in the absence of the service rule. Now to strike that harmonious balance, whether if we have to again judge from the Nagaland police point of view, since they are saying that Jamadar is equivalent to Constable, Subedar Naik and Subedar Major Sub-Inspector. So now let us take that into Nagaland Police Service. Constable is getting direct promotion. Is the Constable directly promoted to Pitas Naik? No. Is the Naik directly promoted to the rank of Sub-Inspector? Naik getting direct promotion. Now, if we have to see from their angle also, Constable is getting directly promoted to Naik. Naik is getting directly promoted to Sub-Inspector.
So in VG, your entry level is Jamadar.
To be recognized by the state government as a government servant. Yes. Because still the rank of Havildar, my lord, that is voluntary service. So the other reasoning also comes where if we are not equal, then our assistant commandant also should be, yes, he should be lower. But that is not the case here. So now by applying the reasonable mind and the intelligent differentia, now whether they are making more sense or the petitioners are making more sense, that is where the harmonious balance is to be struck by this honorable court. Because even if we have to, I'm repeating my lord, my apologies, but even if you have to see from the state's point of view also, a constable is getting directly promoted to Naik, and a Naik is getting next promotion to sub-inspector, and the sub-inspector is next promoted to DYSP or assistant commandant, my lord. Now, even assuming that, while striking that harmonious balance by the genesis of its foundation based on the 1993 ROP rules, when the harmonious balance is to be struck, then even assuming that we are not treated as their equal because of this or the other factor, at least there should be some level of reasonableness that is acceptable. But here it is totally out of context when it comes to the question of reasonability, my lord. May I go to the next case law, my lord? Oh, I think we are time for break, my lord.
Continue.
My lord.
For bail hearing, Itanagar bench. Item number 1.
May I please, Your Lordship?
Yes.
Your Lordship, this is a fourth bail application, Your Lordship.
You have corrected, you have filed the affidavit.
Yes, Your Lordship, I have filed affidavit. Your Lordship, here, Your Lordship, come to page number 20, FIR.
Page 20.
May I read?
1 minute. Yes.
Yes, Your Lordship, FIR dated 8/4/2024. It is to inform you that on 7/4/2024, while Naka checking at Bandardua check gate, 2 persons, namely Sri Nabam Srimoti and Tanatai, were coming from Assam side by motorcycle bearing number AR 02B7011, was stopped at check gate by police check gate team, and one section of 130 CRPF, while checking the motorcycle, found 1 packet of soap case containing pink color powder suspected to be heroin from the possession of Sri Nabam Srimoti. On being interrogated, they disclosed that they have purchased the suspected drugs suspected to be heroin from one Sri Arif Islam of Bujar Bazaar, Bandardua, Assam, and who was connected by their friend, namely Sri Bir Sonar, and further connected by Darej Bora. Accordingly, learned SP Naharlagar was intimated regarding the same, and he verbally directed the OCPS Bandardua to constitute a team. Subsequently, OCPS Bandardua deputed me along with Head Constable SK Tiwari, Constable T. Bomdum, and Constable S. Searing to apprehend the associate and the main supplier. Accordingly, the team apprehended Sri Bir Sonar from Duimok, Sri Daresh Barwa from Harmuti, and the main supplier Sri Arif Islam from Bandardua. Accordingly, the seizure has been made in presence of independent witness. One of the blue color soap case containing oranges colored powder suspected to be heroin. Accordingly, the siege contraband was weighed with the help of digital weighing machine belonging to Bandardua PS case in presence of above mentioned witness, and the net weight 12.37 gram excluding weight of soap. Therefore, I request you to kindly register an FIR under appropriate section of law. Your Lordship, following which, Your Lordship, the accused person was arrested.
Where's
He
the
was
PP? Where's the PP?
PP was here, Your Lordship. Just now he was appearing.
Okay, yes, and then?
Then, Your Lordship, he is in the since then, Your Lordship, he is in the judicial custody. He has spent 1 year, 2 months in the judicial custody. Your Lordship, total, Your Lordship, in the case there were 6 accused. 3 of the accused has been discharged from the case, and the other 2 accused has been granted bail.
Altogether, how many? How many accused?
Total 6.
6. Then out of that,
4
3
discharged. Yes, 3 accused has been discharged.
3 discharged. Then
and 2 of them have been granted bail.
2 granted bail.
Your Lordship, their bail application.
So you're the only one in custody now?
Yes, Your Lordship, I'm the only one.
You were arrested on
8/4/2024. Your Lordship, investigation has been completed, and the police, Your Lordship, has filed its final report in the form of charge sheet. Your Lordship, CC has been taken up.
Yes, yes. Where's PP? And the last order rejecting your bail was passed by NDPS court.
Yes, Your Lordship, special post.
Yeah.
By order dated
That is at page
page number 15.
15.
15. If you load,
We cannot dispose it off without the PP. That's the problem. Yes, yes. Earlier, the one person was appearing.
Your Lordship, that in this case, the matter may be pass over for some time, Your Lordship. I'll contact the PP.
Okay.
Oblige.
Let's keep it here. Yes, please continue.
May it please your lordship. My lord, on consultation, I have learned that there is a draft service rule since 2014, but it has never been publicized. And according to the information of my clients, it may not be the truth. It may not be the absolute truth that can be clarified when the learned additional AG appears.
Even if it's not published, at least some guiding
No,
principles will be there.
what I mean to say is, your lordship, according to the information I received, the draft service rule, which is still awaiting the approval of the government for publication, is most probably that is being kept pending because of this case, the outcome of this case. And the qualification is actually for Jamadar, it is the qualification which is anticipated since 2014, the draft service rule, which is under preparation, is class 10, it appears, not 12. 10 plus. Because out of my ignorance, I do not want to make this honorable court feel misled in any manner. But definitely, your lordship, my lord, this case outcome will determine the service rule also, my lord, which is under preparation. Your lordship, may I take your lordship to 2019 9 SCC, page 209. I'm relying on paragraph 34 and 36. It is on the principle of interpretation of statute. May I read, my lord? 2019 9 ACC, page 209, para 34 and 36. This is Garware Wall Ropes Limited versus Coastal Marine Construction and Engineering Limited. Para 34 is at page 240, my lord. May I read, my lord? In JK Cotton SPG and WVG Mills Co. Limited versus State of UP, this court applied the rule of harmonious construction so that both provisions of a legislative instrument be given effect to. Thus, to remove this incongruity, says the learned Attorney General, apply the rule of harmonious construction and hold that clause 23 of the order has no application when an order is made on an application under clause 5A, on the assumption that under clause 5A, an employer can raise a dispute so to be created by its own proposed order of dismissal of workmen. There is clearly this harmony as pointed out above between two provisions, clause 5A and clause 23. And undoubtedly, we have to apply the rule of harmonious construction. In applying the rule, however, we have to remember that to harmonize is not to destroy. In the interpretation of statutes, the court always presumes that the legislature inserted every part thereof for a purpose, and the legislation intention is that every part of the statute should have effect. These presumptions will have to be made in the case of rulemaking authority also on the construction of On the construction suggested by learned Attorney General, it is obvious that by merely making an application under clause 5 of the allegation that a dispute has arisen about a proposed action to dismiss the workmen, employees can in every case escape the requirement of clause 23. And if, for one reason or other, every employer, when proposing a dismissal, prefers to proceed under 5A instead of making an application under clause 23, clause 23 will be dead letter. A construction like this, which defeats the intention of rule-making authority in clause 23 must, if possible, be avoided. Then para 36, my lord. In Anwar Hassan Khan versus Muhammad Shafi, the court succinctly laid down that what is meant by the doctrine of harmonious construction. It is settled that for interpreting a particular provision of an act, the import and effect of the meaning of the word and phrases used in the statute have to be gathered from the text. The nature of the subject matter and purpose and intention of the statute. It is a cardinal principle of construction of a statute that effort should be made in construing its provisions by avoiding a conflict and adopting a harmonious construction. The statute or rules made thereunder should be read as a whole, and one provision should be construed with reference to the other provision to make the provision consistent with the object so to be achieved. The well-known principle of harmonious construction is that effect should be given to all the provisions, and a construction that reduces one of the provisions to a dead letter is not harmonious construction. Lord, just one line clarification here. Now, even if we have to take the interpretation of the state, if the police is also following the same principle, like from promotion from constable to 2 stripes, and the next promotion to 2 stars, Your Lordship, that itself defeats the very purpose of corresponding rank. So, my Lord, a balance have to be struck there, even if assuming that the interpretation of the state would have more weightage than the interpretation of the petitioners. The divide is too large that it renders the very language of the legislature meaningless, that is entitled to salary of a corresponding rank, my Lord. Yes, Your Lordship. Then, my Lord, the next is 2017-1 SCC, page 148. My Lord, I'm relying on para 42.9. This is State of Punjab versus Jagjit Singh. Now, this is on the parity of pay scale, my Lord. State of Punjab versus Jagjit Singh, 42.9. .9 is at page 207, my Lord.
Yes.
42.9. The reference post with which parity is claimed under the principle of equal pay for equal work has to be at the same hierarchy in the service as the subject post. Hierarchy may be seriously considered here, my Lord. Same hierarchy in the service as the subject post. Pay scales of posts may be different. If the hierarchy of the posts in question and their channel promotion are different, even if the duties and responsibility are same, parity would not be permissible as against a superior post, such as a promotional post. So, my Lord, as far as hierarchy is concerned, there are only 3 ranks to the post of, before reaching the post of assistant commandant or SDPO, DYSP. So, to that extent, my Lord, the uniformity of hierarchy is there, but whether it can be treated equal or not is another aspect, my Lord. Then we come to, my Lord, para 58 and 59. Para 58 is at page 223, my Lord. Para 58. May I read, my Lord?
Yes.
In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in a welfare state. Such an action besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family at the cost of his self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept a lesser wage. Any act of paying less wages as compared to others similarly situated constitutes an act of exploitative enslavement emerging out of domineering position. Undoubtedly, the action is oppressive, suppressive, and coercive as it compels involuntary subjugation. 59. We would also like to extract herein Article 7 of the International Covenant of Economic, Social, and Cultural Rights, 1966. The same is reproduced below. The states parties to the present covenant recognize the right of everyone to the enjoyment of just and favorable conditions of work, which ensure in particular a remuneration which provides all workers as a minimum with fair wages and equal remuneration for work of equal value without distinction of any kind, in particular, women being guaranteed conditions of work not inferior to those enjoyed by men with equal pay for equal work, a decent living for themselves and their families in accordance with the provisions of the present covenant, safe and health working conditions, equal opportunities for everyone to be promoted in his employment to an appropriate higher level, subject to no consideration other than those of seniority and competence. D, rest, leisure, and reasonable limitation of working hours and periodic holidays with pay as well as remuneration for public holidays. India is a signatory to the above covenant, having ratified the same on 10/4/1979. There is no escape from the above obligation in view of different provisions of the Constitution referred to above, and in view of the law declared by this court under Article 141 of the Constitution of India. The principle of equal pay for equal work constitutes a clear and unambiguous right and is vested in every employee, whether engaged on regular or temporary basis. And my lord, the next authority is 1993 supplementary 3 SCC 727 para 13 and 17, my lord. Para 13, my lord, and 17. There's a Supreme Court Employees Welfare Association and Supreme Court Grade for Employees Welfare Association versus Union of India and another. May I read para 13, my lord? The aforesaid recommendation of the Committee of Judges of this court, which have been accepted by the then Chief Justice of India and which are to be forwarded to the President for his approval, cannot be held for the present to be a rule within the meaning of Article 146 of the Constitution, but those recommendations can certainly form basis for issuing interim direction regarding payment of the revised scale to the holders of different categories of posts within the registry of this court. It is an admitted position that the question regarding revision of scale of pay of different categories of employees of this court with effect from January 1, 1986 is pending consideration for more than 7 years. During the hearing of the application for interim direction, we were informed that holders of the corresponding posts of the High Court of Delhi have been getting the revised scale of pay pursuant to the orders aforesaid dated November 4, 1991 and November 14, 1991. There does not appear to be any justification that when the holders of the corresponding posts in the High Court of Delhi are getting scales of pay pursuant to the orders aforesaid, how those scales could be denied to the holders of the corresponding posts of the apex court in the country till the rules come in force. Then, my lord, para 17. Taking the recommendation of the Committee of Judges as a base, we would now dispose of the other interim application mentioned above. In interlocutory application number 4 of 1992, filed by the junior stenographers, it has been contended that the junior clerks of Delhi High Court have been fixed in a pay scale of 1350-2200 from January 1, 1986, By an order of this court dated April 18, 1991, the junior clerks of this court have been granted the similar pay scale of 1350, 2200 with effect from 1986. Now, my lord, the reason for relying upon this judgment is because we are saying that our claim goes back way back to 1993. So whether we can go back to the date of filing of this petition or the date in which the effect was given to, that is 1993, is to be considered. My lord, on the basis of that, I'm relying upon this judgment. Here also it was, the effect was given way back from the date on which the Delhi High Court started enjoying the same benefit, my lord. Then, my lord, 2008, 2 SCC 161. Paragraph 58, my lord. I'm relying on one paragraph. This is on a legitimate expectation, my lord. So when the rule itself provides, there was a legitimate expectation on the part of the petitioners also that they would receive that benefit with effect from the date on which the rule has come into force. May I read, my lord? My lord. This is Jitendra Kumar versus State of Haryana. Paragraph 58, my lord. It's a short paragraph. 58 is at page 183 for holding the same book, my lord. 183. May I read, my lord?
Yes.
An application of doctrine of legitimate expectation or promissory estoppel must also be considered from the aforementioned viewpoint. A legitimate expectation is not the same thing as an anticipation. It is distinct and different from a desire and hope. It is based on a right. It is grounded in the rule of law as requiring regularity, predictability, and certainty in the government's dealing with the public. We have no doubt that the doctrine of legitimate expectation operates both in procedural and substantive manners. Then, my lord, 2014, 14 SCC 272. Now, in this case, my lord is fully aware that when it comes to the bargaining power, we are just a small group of small people against the state. So our bargaining power cannot be compared with the mighty state. That's why this judgment, my lord, 2014, 14 SCC 272, para 21, my lord. This is Mary versus State of Kerala.
21.
Para 21.
Yes.
May I read, my lord? It is pointed out that in a contract of the present nature, the relative bargaining power of the contracting parties cannot be overlooked. Viewed from this angle, the rule is opposed to public policy, contends the learned counsel. Reference in this contention, a connection has been made to a decision of this court in Central Inland Water Transport Corporation versus Brojonath Ganguly. In this case, the terms in the contract of employment as also service rules provided for termination of service of permanent employees without assigning any reason on 3 months' notice or pay in lieu thereof on either side was under challenge. Taking into account unequal bargaining power between the employers and the employee, the terms in contract and the rules were held to be unconscionable, unfair, unreasonable, and against the public policy. On this ground, this court struck down the termination as void. The relevant portion of the judgment read as follows. The said rules form part of the contract of employment between the corporation and its employees who are not workmen. These employees had no powerful workmen's union to support them. They had no voice in the framing of the said rules. They had no choice but to accept the said rules as part of the contract employment. There is gross disparity between the corporation and its employees, whether be workmen or officers. The corporation can afford to dispense with the services of an officer. It will find hundreds of others to take his place, but an officer cannot afford to lose his job because if he does so, there are not hundreds of jobs waiting for him. A clause such as clause 1 of Rule 9 is against right and reason. It is wholly unconscionable. It has been entered into between parties between whom there is gross inequality of bargaining power. Rule 9(1) is a term of the contract between the corporation and all its officers. It affects large numbers of persons and it squarely falls within the principle formulated by us above. Several statutory authorities have a clause similar to Rule 9(1) in their contracts of employment. As appears from the decided cases, the West Bengal State Electricity Board and Air India International have it. Several government employees, apart from the corporation, which is the first appellant before us, must be having it. There are 970 government companies with paid up a capital of rupees 16,414.9 crore as stated in the written argument submitted on behalf of the Union of India. The government and its agencies and instrumentalities constitute the largest employer in the country. A clause such as Rule 9(1) in a contract of employment affecting large sections of public is harmful and injurious to public interest, for it tends to create a sense of insecurity in the minds of those to whom it applies, and consequently, it is against public good. Such a clause, therefore, is opposed to public policy, and being opposed to public policy, it is void under Section 23 of the Contract Act. Now, we are against the interpretation given by the state on the provisions of the rules of 1993, my lord. Then, my lord, on the 2 points, the representation in the last annexure of my writ petition that I was pointing out to your lordship, that we have filed on 21st June 2018, and no reply came, nothing. After more than 5 years of litigation before this honorable court, they produce a document which throws away the entire case. If we have to delve into that question and then give importance to that, then even to challenge that also, they have never given that to us. They have never given us the information. We got a notification, we submitted a representation, no action was taken. After more than 5 years, my lord, this has been brought to the notice of this honorable court, and it is not even given to us. We only came to know through the court, my lord. That also on the insistence of this honorable court.
Through the affidavit?
Yes, your lordship. So, my lord, on this, when the fault is not attributable to the petitioners, whether any relief can be molded by this honorable court in favor of the petitioners or not, I may be allowed to rely on 2 authorities, my lord. 2014 10 SCC 521. My lord, I am relying on paragraph 33.2. This is Chandigarh administration and another versus Jasmine Kaur and others.
On what proposition, this one?
Your lordship, when the fault is not attributable to the candidate or the petitioners in this case, exceptional relief is to be molded by the honorable court in favor of the petitioners.
Mm.
33.2. May I read, my lord? 33.2 is at page 539.
Yes.
Under exceptional circumstances, if the court finds that there is no fault attributable to the candidate, that is, the candidate has pursued his or her legal right expeditiously without any delay, and there is fault only on the part of the authorities, or there is an apparent breach of rules and regulation as well as related principles in the process of grant of admission, which would violate the right to equality and equal treatment to the competing candidates, and the relief of admission can be directed within the same schedule prescribed, it would be completely just and fair to provide exceptional reliefs to the candidate under such circumstance alone. My lord, here we have expeditiously taken the steps to approach this honorable court. They have never brought it to our notice. After more than 5 years, they filed by way of affidavit. And one more, your lordship, 2022, 3 SCC, page 286. I'm relying on para 20, my lord. This is Narendra Singh versus State of Haryana and others. Paragraph 20. May I read, my lord? Once it is found that there was no lapse and or delay on the part of the appellant and or there was no fault of the appellant in not producing the NOC at a relevant time, and when it was produced immediately on receipt of the same, and that too before the appointments were made, and when it is found that the last candidate who is appointed, that is respondent number 4, herein is having less marks than the appellant, thus the appellant is a more meritorious candidate than the last candidate appointed, that is respondent number 4, to deny him the appointment is not justifiable at all. He cannot be punished for no fault of him, my lord. This is important, my lord. He cannot be punished for no fault of him. Both the learned single judge as well as the division bench of the High Court have committed grave error in not exercising the jurisdiction vested in it and in not directing the respondents to appoint the appellant, though he is found to be more meritorious than the last candidate. So, my lord, the principle that is borrowed from this judgment, as my lord has already understood, is that no fault is attributable to the petitioners in this case when the same was never brought to the notice of the petitioners. So, my lord, in short, to sum up my argument, your lordship, starting from 1993, the very word, the interpretation is what is important here, my lord, the corresponding ranks. Oh, my lord, as I will not repeat to the extent of making my lord feel nausea, but
No, the court has to rise at 2:45.
Oh,
Yes.
lordship.
We have a reference, farewell reference.
Oh, my
for
lord.
Justice Kesema and
Your lordship.
Nandi, yes.
So, my lord, let us go to the interpretation of the state respondents once again. That interpretation itself is, there is no harmony at all. There is no reason at all. It is totally discriminatory, my lord. So, my lord, it is my humble submission that if there are 3 points to be considered, my lord, whether it should be with effect from 1993, whether it should be from the first date on which record could be traced out, the first representation, 21/1/2008, or from the date of filing of this writ petition. It is my humble submission that the petitioners require the consideration of this honorable court on all reasonable counts.
What about the anomalies committee rejection of your?
No, that is why, your lordship.
You
That is why, your lordship.
You're not challenging
No,
the.
the last 2 judgments, your lordship. Now, how can they produce that after more than 5 years of the proceedings? Because if we have to go into that question now at this stage, after more than 5 years of the proceedings, then the whole purpose of this writ petition is defeated. We should, the whole meaning is defeated, my lord. So that is my humble submission, your lordship.
Okay. Procurement counsel for the petitioner, Shri Joshua Shetty. The matter is part heard. He said tomorrow, no?
Yes, your lordship.
Pass over. Are there any more cases after this?
It appears there are more cases, your lordship.
I don't think we'll be able to take it up because 2:45 we have to rise. 2:45.
Well, please, your lordship, we have a hearing matter, item number 15. So, lordship, let this matter be listed on 21st. 21st of July, lordship.
Item
15.
21st of July. Prayer of the parties. Then the other one,
Item 13, your lordship. So if it is fixed on Thursday.
Thursday.
Yes.
Okay. If due to paucity of time, the matter could not be taken up. Please the matter on Thursday is what date?
26.
26. Okay, 26.
Please, your lordship.
Is it a small matter or?
No, it is a small matter, your lordship. It will take hardly half an hour. Hardly half an hour. Your lordship.
Last 1 or 2 days, I didn't want to take up long matter, no?
No, a very small matter, your lordship. Very small
CAB
matter.
and then take it around wherever I go.
Yeah. It is very small matter, Your Lordship. Your Lordship, I beg to mention one thing, Your Lordship. In item number 4, I was having interim stay.
Item 4.
Item 4.
Okay, the interim order passed earlier shall continue till the next date.
Much obliged, Your Lordship.
And that, okay. Call.
For bail hearing, item number 1.
May I please, Your Lordship?
Yes.
Your Lordship, here in this case, the charges has been filed. The CC has been framed against the accused person. And Your Lordship, investigation has already been completed.
Yes, Learned PP, I'm granting the bail, okay, because see, 6 of them arrested, then 3 already discharged, 2 granted bail, and he's the only one in custody. So parity, principle of parity also will come. And this is not
As per
yes.
uh,
Yes, I can hear
as
you.
per my as per my record, I
Yes.
received from the lower court.
Yes.
Teacher is available for your lordship,
Yes.
and as per available record in my brief, out of 6,
Yes.
4 were released, and here in this case, this instant accused for whom this application was moved is a main supplier, and though it comes under the intermediate category, intermediate case, which punishment is extendable up to 10 years, and fine which may extend it up to 1 lakh. It's section 21 2B. Your Lordship, when he is admitted in 161, he disclosed on his disclosure other accused.
Yeah, prima facie case is there, no doubt. But is he a permanent resident of this UPIA?
Your Lordship, I'm the permanent resident of Bandar-Dua.
No.
Family is staying there. Your Lordship.
Then
permanent.
He's an Assamese. And Bandar falls under the state boundary between 2 Assam and Arunachal Pradesh. Yes, half portion is on Assam side and half portion is on Arunachal side. And from only local youths only procure this contraband substance from the Assam side only. And here they are always used to escape because there were some territorial jurisdictions and there were easy to hide out in their own states. Your Lordship, primarily if there is a case, then in NDP's case, many youths are where they were spoiled. These suppliers and network contraband something network interested to border.
Bail, Learned PP, the only point for consideration is whether his presence can be secured or not. Isn't it? Whether his presence can be secured. Can you provide a local surety?
Yes, Your Lordship, I can provide you.
Okay. We'll dispose it of. I'll pass order later.
Much obliged.
I'll just pass on the general.
Obliged, Your Lordship.
Yes. Your name, Mr. PP? Your name?
G Tado, additional PP.
Additional
G Tado, additional PP.
Can you just
G
spell it?
Tado.
G
Tado, Tado.
T-A-D-O.
Tado, Tado.
Okay, thank you.
Yes.
Pass over 2018. I have to go to a chamber. Okay.